In my last lecture, I talked about, as it were, the orthodox analysis of mistake of fact, treating it as more or less simply a denial that the defendant had the requisite fault for the offense with which he was charged. In this lecture, I present the more complicated sort of analysis, which has become necessary as a result of the Supreme Court of Canada's analysis, chiefly in Morrison. I think we're going to have to acknowledge right at the outset that the distinction I'm about to draw is, again, complicated, perhaps untenably complicated. There have been some suggestions by some commentators out there that the Supreme Court is going to have to revisit this distinction that I'm about to draw because it is essentially unworkable. But I'm going to try to do my best to sell it as best I can, not because I necessarily believe in it, but because I think if we're going to try to make sense of a line of authorities, we have to look at it in its best light. So here we go. So I'm going to, again, begin with a distinction that is easy to articulate in the abstract, but decidedly tricky to draw in practice. On one hand, keep in mind the absence of belief in a state of affairs or circumstance that, according to the offense in issue, must be present in order to make one's conduct criminal. On the other hand, a positive belief on the part of the defendant in a circumstance that, if true, would make his or her conduct non-criminal, at least in the narrow sense of not being contrary, again, to the specific offense with which he or she has been charged. So, absence of belief on one hand, positive belief, mistaken belief on the other. Now, these two are obviously related. If one has a mistaken belief in a circumstance, then one must also have an absence of belief in the state of affairs that, according to the offense in issue, one must have in order to be guilty of the offense with which the defendant's been charged. But the reverse isn't true. One may have a pure absence of belief about any state of affairs, and thus lack the requisite fault for the offense in issue without having made, as it were, a mistake. Put hopefully somewhat more simply, if one has a sheer absence of belief, then one has simply failed to turn one's mind altogether to whether or not this circumstance exists, or this circumstance exists, or indeed whether any circumstance exists. One is simply approaching the conduct in issue as though the existence or non-existence of the circumstance set out in the offense is just a non-factor. And to the extent that the defendant embarks upon his or her course of action without even turning his or her mind to whether or not this circumstance exists or that, well, we can't exactly say that the defendant makes a mistake. That seems like a stretch of language. Instead, we are simply talking about an absence of the requisite fault. Now, where an offense is one of subjective fault, and that's really what I'm going to be focusing on, subjective fault offenses here, the sheer absence of thought as to the existence of a circumstance may well be enough to warrant an acquittal. If an offense requires proof that the defendant knew of a state of affairs, then the absence of thought as to that state of affairs means that, in principle, the defendant must be acquitted. Furthermore, there's no willful blindness to the extent that the defendant simply, again, gives the existence or non-existence of this state of affairs no thought at all. because, of course, again, willful blindness is a subjective fault standard and requires the defendant to have turned his or her mind to the need for inquiry. Well, if the defendant simply gives no thought whatsoever to the presence or absence of the state of affairs set out in the offense provision, well then, he or she can't be willfully blind either. And finally, if the offense can be committed recklessly, then the defendant must subjectively appreciate the risk that the circumstance exists. And to the extent that the defendant does not give even a thought to that risk, well then, strictly speaking, there's no recklessness either. Now, practically speaking, there's a big giant but attached to all of this. Because practically speaking, where the circumstance or state of affairs set out in the statute would be salient to most of us under the circumstances, well, the defendant will have a tough time arguing at trial that he or she didn't turn his or her mind at all to its existence or even the risk thereof. But always remember, of course, that there's nothing to compel the trier of fact to find that the defendant must have known or been willfully blind to or appreciated the risk that the circumstance existed. In every case alleging that the defendant committed an offense of subjective fault, the Crown must prove beyond a reasonable doubt that the defendant knew, was willfully blind to, or appreciated the risk that the circumstance in question existed. So that's the significance of the absence of belief in the context of many subjective fault offenses. Contrast the sheer absence of belief, the sheer absence of thought, with the presence in the mind of the defendant at the relevant time of some mistaken belief in a circumstance that, had it been true, would have made the defendant's conduct essentially compatible or compliant with the offense provision in issue. In such a case, the defendant doesn't just deny knowledge or suspicion or appreciation of the risk. He doesn't just deny having turned his mind to the existence of the state of affairs, again, set out in the offense provision. He or she insists that he or she was proceeding on the basis of an alternative set of beliefs that serves to explain his conduct. Now, this is quite important in practice, I suspect. A trier of fact may, as we have seen, hesitate to infer that an apparently normally functioning defendant was completely oblivious to a salient state of affairs or circumstance, or didn't even stop to ask for a moment the sort of question that any ordinary human being would have asked. But some of that hesitation may drop away where the defendant makes the positive claim that he or she made a mistake. The claim that the defendant acted on the mistaken belief that a different state of affairs existed may be easier to swallow than the idea that the defendant embarked upon his course of conduct simply, as it were, with a mental state akin to a vacuum. And to that extent, a mistake arguably, or a claim of mistake, maybe, as I say, just easier to digest for a trier of fact. And importantly, though, we don't simply allow the defendant just to waft claims of mistaken belief towards the trier of fact. The defendant must present some evidence on that point, if only his or her own testimony. If the defendant does adduce some evidence to support the inference of mistaken belief, then the matter will be decided by the trier of fact. And to get a conviction, the Crown's going to need to disprove the existence of the mistake beyond a reasonable doubt. If, however, the defendant doesn't adduce sufficient evidence to give the claim of mistaken belief an air of reality, then the trier of fact will not, in principle, need to consider the claim at all, and the Crown won't need to disprove it. By contrast, the Crown always must prove beyond a reasonable doubt, again, if the offense is one of subjective fault, that the defendant had a belief in the state of affairs or circumstance set out in the offense, that he was willfully blind, or that he appreciated the risk. That is always the case. Whenever we're talking about a subjective fault offense, that's what makes it an offense of subjective fault. So right away we can see that the courts have drawn a distinction here between claims of absence of belief, for which the defendant need give no air of reality, because it essentially just amounts to a denial of the Crown's claim that the defendant possessed the requisite state of mind. And on the other hand, claims of mistaken belief, for which, if the defendant is going to have that claim assessed by the jury or the trier of fact in the first place, must provide an air of reality, must adduce some evidence on that point. Now, as I said at the outset, I'm trying to do my best to sell this distinction between absence of belief and mistaken belief. But let's be clear, it's a tricky distinction to draw. Certainly in practice it is. And it may even be tricky to draw in theory. After all, the only reason we care about a defendant's mistaken belief is that it establishes, if successful anyway, that the defendant lacked the belief set out in the offense provision. We don't care about the mistake as significant in and of itself. We care about the mistake because, in a relevant legal sense, it establishes absence of belief in whatever circumstance was set out in the offense provision. So it may well be that not just at the level of practice, but at the level of theory, this distinction between absence of belief and mistaken belief just breaks down. However, what I've been trying to get across so far is that we can see some of the seeds of this distinction being planted even way back in the 1980s, particularly where the Supreme Court articulated an air of reality test for mistaken belief, but articulated no such test for absence of belief. And again, on one level, maybe that makes sense, because what would it even mean to set out an air of reality test for absence of belief? After all, if the defendant is claiming absence of belief, all he or she is really doing is simply denying the charge, right? It's the Crown that has the burden of establishing that the defendant had a belief in some circumstance, or that the defendant had an appreciation of the risk of some circumstance, or that the defendant was willfully blind as to some circumstance. To claim absence of belief is simply to say to the Crown, no, I didn't have that belief. No, I didn't appreciate that risk. To impose an error of reality test in the context of absence of belief would be essentially to flip the burden of proof onto the defendant to disprove that he was guilty or she was guilty of the offense charged. And that plainly would suffer from serious constitutional problems. So it's not a surprise that the Supreme Court didn't specify an error of reality test for mere absence of belief, for claiming mere absence of belief. But again, the interesting question is, in setting out an error of reality test for mistaken belief, has the Supreme Court, in a sense, drawn a distinction that really can't be sustained? Because again, why do we care about mistake in the first place? Only because it reinforces the claim that what the defendant didn't have was the sort of belief or state of mind set out in the offense provision in issue. So again, it may well be that this distinction between, should we even want to make this distinction, between absence of belief and mistaken belief has roots going back to the 1980s, particularly in a series of cases where the Supreme Court was responding to concerns about the defense of honest but mistaken belief in consent in the context of the offense of sexual assault. But matters have really come to a head, and the significance of this notional distinction between absence of belief and mistaken belief has really become greater because of a number of provisions that we can find in the code, notably in the sexual offenses, that restrict access to the defense of honest but mistaken belief. And these are what we might loosely call reasonable steps provisions. And here you'll note that section 273.2 sub B states that essentially the defendant can't claim or can't leave the defense of honest but mistaken belief in consent with the jury or the trier of fact unless the accused can make out or establish, put some evidence on the record to show that he took reasonable steps in the circumstances known to him at the time to ascertain that the complainant was consenting. So in effect, what this provision does is say, you don't get to leave the defense of honest but mistaken belief in consent with the jury or with the trier of fact unless you are able to put some evidence on the record to show that your belief in consent, if you indeed had such a belief, was based on something. And notably, to take reasonable steps to establish that, yes, indeed, this individual is consenting to the sexual touching in issue here. And here's another example, section 150.1 sub 4 of the criminal code. This applies to a number of sexual offenses involving minors. And what this does is restrict availability of the defense of honest but mistaken belief that the complainant was of a certain age. And that the complainant was 16 years of age or more, so of an age of consent. And notably, again, what does it say? It says you're not allowed effectively to make that sort of claim. You're not allowed to leave that sort of defense of honest but mistaken belief in age unless you establish on the record some evidence that you took all reasonable steps to ascertain the age of the complainant at the time. So again, same sort of idea. You're not allowed to leave the defense of mistake of age with the jury, with the trier of fact, unless you establish that your belief was, again, based on something. And indeed, this provision is somewhat different from 273.2 sub B, because whereas that provision required the defendant only to put forward evidence that he took, as it were, some reasonable steps, this provision requires the defendant to have taken all reasonable steps to ascertain the age of the complainant. And I would just note that in sub 5 and sub 6, we see other reasonable steps requirements being imposed on defendants who wish to argue honest but mistaken belief in the context of various sexual offenses involving young people. And here we have one further example. This is section 172.1 sub 1, which creates the offense of child luring. So if we imagine a defendant communicating with someone who is, or who the defendant believes to have been, under a certain age, and is engaging in this communication for the purposes, as it were, of grooming that person for sexual acts, then that amounts to effectively the offense of child luring. Obviously, that's a very loose way of describing the offense, but it's all we need to get into for our purposes here. And then if we go down to sub 4 of section 172.1, we see that if the defendant wants to say, well, look, I made a mistake about the age of the person with whom I was communicating, well, in order to make that sort of argument and have it left with the jury, or have it left with the trier of fact, again, the defendant must first adduce evidence to show that he took reasonable steps to ascertain the age of this person, again, by way of showing that his mistake, if indeed he made a mistake, was based on something. Now, clearly what all of these provisions have in common is that they express a concern on the part of Parliament that it may well be too easy for defendants to claim that they had a mistaken belief in consent, or a mistaken belief about the age of the person with whom they were communicating or engaging sexually, or inviting to participate in sexual activity. And to that end, Parliament has restricted access to the honest but mistaken belief honest but mistaken belief defense by saying, well, no, in order to even have this defense left on the table for the trier of fact to decide, you need to show that, or at least you need to adduce some evidence capable of showing that you took some or all reasonable steps to ascertain the circumstance in issue. I've just given two quite different rationales for the reasonable steps provisions. The first is, we might say, an evidentiary rationale. We worry about defendants who find it rather too easy to assert the defense of honest but mistaken belief. We worry about these stories which may be baseless, distracting the jury, about a jury essentially being too ready to accept the defendant's claim of mistake. And to that end, we impose an evidentiary hurdle, a procedural hurdle on any defendant who wants to claim honest but mistaken belief. That's the word evidential or procedural or adjectival framing of the reasonable steps provision. But there's also a substantive framing here too, right? Because to the extent that the point of the reasonable steps provision is actually to communicate a message not to defendants, as it were, but to proto-defendants, to ordinary citizens who are engaging sexually with one another, purporting to send the message, look, if you are going to engage sexually with another person, then you have to turn your mind to whether or not that other person is consenting. You have to turn your mind to whether or not that other person is of an age at which they are capable of consenting. And to the extent that the provision speaks not just to defendants, but to ordinary citizens, we might well wonder if it isn't a substantive offense provision, if it doesn't effectively set out an alternative route to committing the offenses that I've been talking about. So, at risk of belaboring the point, I'm just going to speak a little bit further on this distinction, because it matters a great deal how we think about these reasonable steps provisions and what kind of provisions they are. On the one hand, as I say, we might think of these provisions as substantive provisions. And if so, then they tell us not just when a defendant can leave the defense of honest but mistaken belief with the trier of fact, and how it may or must be proven, but it sets out one way in which, quite simply, a person can engage in the offense of sexual assault or child luring or one of a number of other sexual offenses involving children. Now, if that's the correct reading, then it effectively means that offenses like sexual assault, child luring, etc., are functionally offenses of objective fault, because they communicate that one can commit the offense in question by failing to act reasonably in ascertaining age or consent, or indeed that one can commit these offenses by failing to turn one's mind to the question of age or consent at all. Now, until recently, I might have said that there was some good authority on the books for the proposition that these reasonable steps provisions are substantive provisions setting out alternative paths to liability, notably paragraph 8 of the Queen versus George, where it sure sounds like the Supreme Court is saying just that. However, that passage in George has now been, shall we say, aggressively reinterpreted by a majority of the court in Morrison. In Morrison, a majority of the Supreme Court more or less rejected expressly any understanding of the reasonable steps requirement in the context of the offense of child luring as a substantive provision that effectively made that offense one of objective fault. In getting to that conclusion, the majority in Morrison pointed to reasonably clear textual and contextual clues that Parliament intended this offense to be subjective. The majority pointed to express language requiring the defendant to have believed that the complainant was underage. And there were clear signals that Parliament thought that proof of belief was an essential for this offense, precisely because another subsection, subsection 3 of 172.1, offered the Crown, as it were, a streamlined way of proving belief in a belief that the complainant was underage. Now, why go to all that trouble if, in fact, the Crown can get a conviction simply by showing that the defendant acted unreasonably, informing his belief about the age of the complainant, or gave no thought to the complainant's age at all? If this offense is an offense that can be construed at all as one of objective fault, this language of subjective fault, these provisions making it easier to establish subjective fault, just don't make any sense. Why go to all that trouble if objective fault is all you need? Now, the interesting question is, okay, if that reasonable steps provision in the context of the offense of child luring doesn't make the offense one of objective fault, why think that other reasonable steps provisions do? Why treat that reasonable steps provision as evidentiary, adjectival, procedural in nature, not substantive, not setting out an alternative path to liability? Why take that view on that reasonable steps provision, but not take a similar view on the other reasonable steps provisions? And notably, it would particularly seem as though, for example, reading 273.2 sub B of the Criminal Code, which applies to sexual assault, treating that provision as one that makes the offense of sexual assault a crime of objective fault, that would really seem to be in tension with decades of jurisprudence that have seemed to proceed on the basis that the defendant must have knowledge of lack of consent or must be reckless as to lack of consent. And just to pick up this thread a little bit further. So I've been saying so far that the majority in Morrison does not read the reasonable steps provision in the context of the offense of child luring as a substantive provision. It treats that provision, the reasonable steps provision, as essentially evidentiary in nature. It sets out the conditions under which a defendant can leave the defense of honest but mistaken belief in age with the trier of fact in the first place, but it doesn't fundamentally change the elements of the offense of child luring. But doesn't it really, you might well ask? I mean, if the defendant fails to adduce evidence that he took reasonable steps to ascertain the age of the complainant, well then, what's going to happen is that the defendant will be barred from leaving the defense of honest but mistaken belief with the trier of fact. The trier of fact won't be able to consider it, at least in principle, and the Crown won't need to disprove honest but mistaken belief beyond a reasonable doubt. So you might well ask, how does this not effectively change the path of liability? Well, it doesn't, because what the Crown still needs to do, says the majority in Morrison, is establish that the defendant believed that the person with whom he was communicating was underage. So the Crown still has to prove that. It just doesn't need to disprove the claim that the defendant had a mistaken belief that the complainant was over the age of consent. Confused yet? If you're confused, that's okay, because it goes to, again, the decidedly complicated and arguably untenable distinction between absence of belief and mistaken belief. Because that's what the majority in Morrison is really getting at, right? That it's okay that we've restricted the defendant's ability to argue honest but mistaken belief that the complainant was over the age of consent, because the Crown must still prove that the defendant had a belief, that there was no absence of belief, that the complainant was under the age of consent. And indeed, to the court, to the majority in Morrison, this distinction is all important, because if somehow this provision relieved the Crown of proving that the defendant had a belief that the complainant was underage, well, then suddenly we would have a serious presumption of innocence problem. Suddenly we would be putting the burden on the defendant to disprove an essential element of the offense, namely the fault requirement. And quite simply, the court in Morrison isn't prepared to go there. So the distinction that I started with in this lecture between absence of belief and mistaken belief is arguably central to the majority's analysis in Morrison. It's arguably central to the majority's explanation of why it is that this reasonable steps provision, which is not substantive in nature, which is purely evidentiary and procedural, is constitutionally unproblematic. And what's more, the majority, in the course of interpreting those remarks in the Queen versus George, to which I referred earlier, those remarks in paragraph 8 of George, the majority in Morrison suggests that similar reasoning should be employed when making sense of reasonable steps requirements in the context of the offense of invitation to sexual touching and sexual assault. And there we are. I suspect this lecture will make a great many of you unhappy. I can't say it makes me terribly happy either, if for what it's worth. As I've tried to stress, I am not oblivious to the fact that the distinction between absence of belief and mistaken belief is, in practice, tricky, perhaps untenable, and even in theory, possibly indefensible, given why it is that we think, traditionally anyway, mistaken belief matters at all. Nonetheless, we have to live with the law we've got. And the decision in Morrison, coupled with a much longer line of authorities suggesting that there is an error of reality test for the defense of mistaken belief, but no such test for absence of belief. These, as it were, clues suggest that we have to at least be prepared to entertain the idea that there is something that can properly turn on this distinction between absence of belief and mistaken belief. One last point at the end of this rather vexed discussion. We might well wonder why it is that a defendant's sheer failure even to turn his or her mind to, say, consent or to the age of one's sexual partner should earn that individual an acquittal. We might well think that that sort of attitude to consent, or to whether or not one's partner is of an age at which they even can consent, that is not just blameworthy, but seriously blameworthy. Yet it's clear in Morrison that the one thing that makes the reasonable steps provision constitutional in the view of the majority is the fact that, in principle, yes, the absence of belief can earn a defendant an acquittal. the Crown must disprove absence of belief and show that the defendant at the relevant time positively believed that the complainant was not consenting, or that the complainant was below the age of consent. It's pretty clear that in the view of the majority in Morrison, that is the only thing that makes this reasonable steps provision constitutionally palatable. And that's going to stick in our craw. Surely the point of many of these provisions, particularly the reasonable steps provisions, is to encourage us to adopt a very different attitude, to treat the consent of the other party, to treat the age of the other party as factors that should loom large in our mind, and that if we are not paying sufficient care to these matters, well, we should pay more care. And that's the point of the reasonable steps requirements, or at least so we might think. To think about the reasonable steps requirements in that way is, again, to treat them as substantive provisions. To the extent that the reasonable steps requirements contained in the provisions governing sexual assault, child luring, and other sexual offenses involving minors, to the extent that we think that these provisions are not intended to be merely evidentiary or procedural, well, the clear message from the majority in Morrison is you're going to have to, you being Parliament, go back to the drawing board and be more clear about what the fault requirement is for these offenses. If you want to say, again, you being Parliament, that these offenses are offenses of objective fault, that a mere lack of care as to another person's consent or another person's age, that a mere lack of care is enough to make you criminally liable, you're going to have to say so. And you're going to have to say so in far more express language than you've done so far.